this seminar.
Sorry. 1 second.
Me okay? Because everyone can hear me, so I'm assuming that that's the case, which is wonderful. Okay, good afternoon, everyone. Thank you for joining. I'm sorry we started a little bit late. We were just sorting out the technical issues. I'm conscious that some of you might be joining this over your lunch break. So even though I have some 56 slides to get through, I'm going to do my best to do it in an hour, and I'm going to ask you to time me in case I can't. So you've come today to learn about a good practice guide and how to treat trans people in the family courts. Just as an introduction to you all, I'm Reagan, if you've not met before, and I am the only trans barrister in the country that is of an ethnic minority background. And I am one of, say, 5 or 6, I think, as a whole, trans barristers in the country. So there aren't many of us around, but there are a handful of us. And I think because of how small a number we are, we're very conscious, I'm certainly very conscious, that it's important that people are educated about these issues and that nobody gets it wrong, because I don't think professionals want to get it wrong. It's just a tricky area to deal with. We know that the most recent census in the United Kingdom showed, for everyone who returned the census, that trans people make up about 0.5%, about 0.5% of the population in the country. And we know that that small percentage, that an even smaller number will be coming to the family courts, an even smaller number will be children who are trans who are coming to the family courts. And so trans people as a whole are, if not one of the smallest minorities in the country, it's the smallest minority group in the country. Saying that, we are finding, and I think certainly I'm finding in my practice, and I imagine a lot of you are, that trans issues are arising more and more in family cases, and in particular children cases. And so I think it's important for us to understand how we deal with these issues and how we deal with them in the right way. So what we will cover today, therefore, is under 3 broad headings. I'm going to give you a broad overview of relevant terminology, pronouns, titles, what would likely be general good practice for practitioners. I'm going to give you some relevant law around the issue of LGBTQ generally in the family courts, and I'm going to bring you up to speed in terms of some more trans-specific cases. And then I'm going to give you finally some guidance on actually what, now that we know the right terminology, pronouns, titles, and we know what the law says, good practice would look like in a courtroom setting and for you as a lawyer working with either trans adults or trans children. So I'm going to take the first part, which is the broad overview of matters. And this is a very broad overview. This is to give you an introduction to trans issues. And so the first thing I want to start with is terminology, because when it comes to these types of issues, there is a lot of terminology, and it's very much, I think it can be, if you don't know the right terminology, it can be a bit of a minefield, and no one wants to get it wrong, and you want to say the right things. So let's tackle that first. There is an issue, there is a difference between sex and gender, and certainly when it comes to trans issues and standard language used these days, what sex refers to is a biological or a physiological characteristic. So what I mean by that, I always relate these things to myself because I think it's the easiest way for people to understand. But in terms of sex, I would be male because I was born a boy. Gender, however, is a social construct. It is a social or cultural presentation, and it is how you choose to present yourself. For me, my gender is female, and so I have socially transitioned to being female, and I live my everyday life as a woman, and so my gender is female. People might say, well, aren't they the same thing? But certainly from a sociological perspective, from a trans perspective, they are very, and from a psychological perspective, they are very different things. It's sometimes said in the trans community that if you locked a child up when they were born and raised them in a very isolated setting, a white room kind of setting, into adulthood, without introducing them to the social norms that come around being a boy or a girl, you would find that they don't have a concept of that when they become adults. And they don't know what boys are supposed to do, how boys are supposed to dress, that short hair is normally associated with boys. They wouldn't know all of these things that we call gender issues. social construct issues. And so that is where the difference comes in, and that is why we draw the difference, because one is taught a social behaviour and one is a biological, physiological characteristic. So that's the broad difference that you might come across. In terms of trans as an idea, as a concept, I think it's important to say that trans is an umbrella term. There's no one person that fits under the trans umbrella. It is a spectrum. And yes, there is a spectrum, for those of you who didn't know. It includes those whose gender identity don't conform to the gender assigned at birth. So myself, I've transitioned and now I identify as the opposite gender. But it also includes those whose gender identity is not entirely consistent with what was assigned at birth. And what they mean by that is, for instance, non-binary people, agender, so people who don't identify with a particular gender, male or female, non-binary people who may feel, who may go between the two or may choose that actually they don't wish to be identified in a binary system, gender fluid, gender queer, all of those people would still fit under trans. So it can be people who move to the opposite gender. It can also be people who don't fit one, go between the two, people who don't wish to be identified with any gender at all. There is a broad spectrum. The one thing I would ask you to take note of is a concept of what people say as a transsexual. Now, one of the issues the trans community faces is that we are incredibly sexualized as a community, and we are seen by many, sadly, as a fetish item. The term transsexual carries those sexual elements to it. And so it was an old-fashioned term used in the 50s, 60s, 70s. It's considered outdated. And I would ask you to strike that from your vocabulary because it will offend trans people. It certainly offends me if I'm referred to as a transsexual, because there is nothing sexual about my identity as far as I'm concerned. So it's transgender, or it's broadly trans is the heading they would fall under. So then we look at trans man stroke woman as some helpful terminology. That's a man who's transitioned from female to male, or a woman who has transitioned from male to female. So I'm a trans woman. Contrast that with cisgender, or cis man, or cis woman, who is a person who's not trans. So if you are your assigned gender at birth continues to match your gender identity now, then you are considered cis. You are considered a cis woman or a cis man, to draw the differentiation between the two. Assigned gender is the one recorded at the birth. Acquired gender is the one that you then transition to identify with. So my acquired gender is female, my assigned gender at birth was male. And as it says there, it can happen through recognizing a gender recognition certificate, or actually just from identifying and saying, I wish to now identify as female, and going through that process. That is a process. There's no legal requirement to necessarily obtain an acquired gender. Although you can formally acquire it through a gender recognition certificate, it is not legally required for you to be identified as the opposite gender or in a different role like genderqueer, gender fluid. And transitioning, if someone says to you, I'm transitioning, what they mean is they are going through the process of changing gender from male to female, from female to male, and they can be it has certain limbs to it. So I put their social limb, so dressing, presentation. For me, that was growing out my hair, taking hormones, changing my body physically, which overlaps with medical changes. And then there are physical transition changes in terms of things like my nails, wearing makeup, all part of social, medical, and physical transition. So transitioning can refer to all of that. Another faux pas you might want to watch out for is some trans people, when they have acquired their gender fully, they feel that they have gone through this process, will turn around and say, I am not transitioning, I have transitioned. I am a woman now, I no longer am transitioning. Personally for me, and it is a personal journey for everyone, I very much take the view that a person is always transitioning when it comes to these particular issues. There's always something to learn. There's always something that I will consider and adapt and grow from. And so I always say to people, I'm always transitioning, notwithstanding the fact that I've lived as a woman now for coming up to 10 years. So that's some helpful terminology, very basic introduction to it. Let's continue. Passing. Now, passing is how well you pass in society unnoticed as your acquired gender. So for me, most people don't know that I'm a trans woman. I will go through life just being seen as a normal woman. I didn't say normal woman, I didn't mean that, but I'm sure you all understand what I mean. I meant cis woman. And that means that I have something called passing privilege. I'm sure you've heard the concept of privilege before. For me, I get the privilege of passing as my acquired gender without any of the prejudices that might follow my sisters and brothers who sadly don't have that privilege, that they don't pass as well. And sadly, there is a lot more bigotry directed towards people when they don't pass well. Because for me, I can choose who I tell that I'm trans. I can decide not to tell people. I can get about on a day-to-day basis without worrying about people questioning what toilet I use because I pass fine, but other people might find that that journey is harder for them. And we will discuss that further as this seminar continues to assist you to understand the type of issues you might have to deal with. If a trans person says to you, you have misgendered them, misgendering, that is calling a trans person by the gender which they no longer identify. So a very good example of it is using incorrect pronouns. For me, if someone calls me he, that would be misgendering me. And again, it's linked to privilege because I have passing privilege means that I don't have that problem. But again, a lot of my trans sisters and brothers will do. And we will discuss pronouns a little bit later, but I just want to flag here that one of the most painful things you can do to a trans person is not to recognize the identity that they work so hard. And believe me when I say you have to work hard to transition. For you to turn around and misgender them can be an incredibly personal and painful thing. Let's look at dead naming and slave naming, which again, it's used interchangeably. When I was younger, I would used to call it slave naming, was the word we used to say for it, which is you've tied me to my name at birth, my slave name, because that was given to me. I didn't get any choice in that. And so you've tied me to it. Modern day, 2023, it's more commonly referred to as dead naming. You've tied me to the name that is dead, that isn't who I am, referring to the person's previous name. Either terminology, be aware of it. And so I wanted to flag here just around this, because again, when someone has worked very hard to transition, it is a hard process. You have to do it socially. You have to tell your friends. You might lose friends. You might lose family. You might find that there are difficulties in employment. You start hormones, and there is an incredibly painful process with the hormones that can affect how you function on a day-to-day basis. You have to go through the prejudices of not necessarily passing at first and then gaining passing privilege if you're lucky, or if not, remaining someone who stands out in society and will be looked at funny and be picked on. It is a very difficult journey, and I want to get across to you that I don't think anyone goes through this and will follow it all the way through in that way unless it is something that is incredibly important to them and incredibly in line with who they are. When you misgender them or slave name or dead name them, that is an affront and an attack to who they are fundamentally. At least that's certainly how it feels. And so we must be mindful that if there's anything we go away and learn from today, is that those things are the things that you want to tackle the most. That will be the most important to a trans person, in my opinion. How to deal with it then? Because you might have a situation where someone has legally changed their name, and so of course you refer to them by their new legal name. But as I said to you earlier, transitioning can be social, medical, physical, legal. Sometimes, a lot of the time, people can say, like for instance, trans children will say, I know that I've been given the name, I don't know, Joe at birth, but I want to be known as Francine. They don't have the power to change their name. That's not up to them. And so how do you deal with it if a name is not legally changed? Well, actually, there's nothing in law stopping you from referring to the person by the name that they tell you is the name that they, identify with. And in fact, it can be incredibly important for non-binary people if they choose a gender-neutral name or a name that they feel represents who they are, that is the name they refer to. If it's not legally changed, then what do? Well, names again, social constructs. Call the person by the name they want to be known as. And when it comes to what you do in terms of recognizing that person's name on formal documents, I always say to people that actually, in terms of names on a day-to-day basis, you can be called whatever name you choose to be called. It's only when you come into contact with arms of the state and formal processes that you need a legal name to get by. And so what you should do as professionals working with these individuals is this. Set out on a preliminary document the person's legal name, but make reference to the fact that they prefer to be known by X name, and that going forward they will be referred to by this name on all documents. This can apply to court orders. Set it out on the first court order. It can apply to documents held by dentists, GPs, social services records, and then you always use the name that the person identifies with thereafter. That is if the name is not legally changed. It's a great way to link back to the legal name, but also show respect to the person for the name that they have chosen. And it's incredibly useful when you have children who can't change their name legally 9 times out of 10 because it's not up to them, to still show respect for who they are. What I would say, though, is if you don't do that, or even if you do that and you still have to be careful with a person's identity following from that, is be conscious of how you store and handle this information on your systems. Because, excuse me, the case of D'Souza and Primark was a case which involved an employer, D'Souza, choosing to be identified by a different name, and their employer refused to use that name because it wasn't their legal name. On all documents, including things like internal emails, would only use that person's legal name on internal emails. That led to everyone in the office knowing about outing this person, in essence, as trans, and that led to D'Souza being bullied. And as a result, there was a claim brought against Primark, and they lost, and they were told, actually they had to pay damages, and they were told that they should have made more efforts, even if that person's name was not their legal name, to recognise their preferred name and to do what I've just said to you, really, to set out on a preliminary document that can be kept confidential for those who need to know it and see it, that this is the person's legal name, but they're referred to as X name, and that is the preferred name that should be used. So that's the concept of slave naming, dead naming, and misgendering, and how to avoid it in your practice. Let's talk a little bit more about the concept of trans. We've dealt with terminology. One of the things I want to flag to you, as I've said, is that trans people are one of the smallest minorities, if not the smallest minorities, if not the smallest minority of people in England and Wales, and actually across the world. There is some evidence that in terms of being trans, the dysphoria comes from genetics, and there's some evidence that it comes from environmental factors. For those of you who don't know what dysphoria is the feeling you have whereby your sex doesn't align to your gender, whereby the assigned gender at birth doesn't match the acquired gender. And trans people who have this feeling, trans people, are considered to have gender dysphoria. That is a medical terminology. And as I say, the dysphoria, the feeling that you don't align in that way, comes from genetics or comes from environment. There's evidence that some of this comes from both sides. It's still quite a I suppose, novel concept. People don't fully know where it comes from. The same way you'd have LGBT people, and you can't say being gay comes from genetics or comes from social factors. It just is, isn't it? Many trans people have a concept of feeling different from about the age of 5, and they don't always know what this feeling means, but they know that they have dysphoria. So I'll give you an example of me. When I was little, I remember at 4, we were very Christian as a house, and my mother would always say to me, "Oh, if you want anything, just ask Jesus for it and you'll have it." And so I used to get on my knees at 4, and I remember this, and I used to pray every night to be a girl and then go to sleep really hoping I'd wake up a girl. And I never woke up as a girl. But looking back now as an adult, I can see that from the age of 4, I had these very strong feelings to be a girl, but I didn't know that that meant I was trans. I didn't know that dysphoria was a thing. I didn't know that I aligned in this way. The reason I'm telling you this is because you might work in particular with children or young, vulnerable adults who think in a less sophisticated way, who may express concepts that you may need to be conscious of, might point to dysphoria, might point to these issues, and might require them to get some support to understand one way or the other what it is they're going through. So be conscious that there is no age limit on this. And in fact, I'll come back to a case later on this, where I'll talk about this in some more detail, because even the court has recognised that there is no age limit on this. One of the other things you want to look out for is the fact that when young people, children, start to go through puberty, if they have dysphoria, there can be considerable distress at what starts to develop. Because for me, I remember when I started to develop chest hair and facial hair, it was very upsetting for me, because of course I always wanted to be a girl. I always felt like a girl. I always thought I was a girl in my head, and that was a very outward sign that I wasn't. If you are representing those vulnerable young people, be conscious that that is a time period that might then trigger issues for them. And that is a time when you might have to start to think about things like, do they need to go on puberty blockers? I'm not going to deal with puberty blockers in this seminar. There's just not enough time. I can do in a different seminar if you require me to. But as an overview, very briefly, the Gender Clinic, which is run by the NHS and caters for all trans people, has 6 branches across the country that offer gender services, including things like medical treatment, puberty blockers, etc., to trans adults across the country. The Tavistock Clinic is the one that deals with trans children, and the Tavistock Clinic is based in London and has an annex branch in Leeds. The reason I flag this for you is if you are dealing with the case of a trans child and you are conscious that this child might be hitting puberty soon and that might distress this child, please be conscious that you need to get this referral in, and the referral can happen through the GP, who then passes it on to the relevant gender clinic ASAP, because the waiting lists for these clinics, thanks to the budget cuts, is horrific. Some clinics you're waiting 3 to 6 years for a first appointment, and then there are waiting lists internally. There is a lot of controversy recently around the Tavistock Clinic, but please be rest assured that the Court of Appeal has decided that Tavistock Clinic in Bell and Tavistock are fine to do what they're doing. They understand how to treat children and they're doing the right thing for children. And again, I can do a whole seminar on this issue of the legal process of transitioning and the medical side of things and what the law says if required. But Tavistock is very good at what they do, and they don't just put people on puberty blockers. There are children who have to wait 5-6 years of constant consideration and assessment of their situation, how they're feeling and what their thoughts are, before they can look at going on puberty blockers. Puberty blockers are also not permanent. Puberty blockers do what they say. They pause puberty, they block puberty until that individual is emotionally and mentally mature enough to make decisions about where they want to go. At which point, if they want to transition, they could be put on cross-sex hormones. So I am on estrogen to transition as a woman, or they could go on testosterone if they are assigned female at birth, but wish to transition to male. Puberty blockers simply allow them time to decide and to make an informed decision as they grow into adulthood. And if they decide, no, I don't want to do that, they come off the blockers, puberty will happen as it should. If they decide, no, I do want to do that, then they can transition the other way. It is wonderful for children showing distress in puberty, and it also means that some of the irreversible parts of puberty can be avoided for those children if they later move on to transition. So just be conscious of that. Be conscious of puberty blockers and distress in puberty, and the necessary referrals because of the waiting lists that might follow. So how do you respond then when this type of issue comes up? Either you're working with trans people or you're coming across trans children who need support in your practice. Well, I always say, remember that a lot of this is empathy. We have to have empathy, because it's a battle in the mind. Being trans is a battle in the mind, and it can be torture. I had many years where I was, I want to say I was 2 people, but I wasn't. I just had 2 personas in my head. And notwithstanding how much I tried to be male and be this person that the world was telling me to be, this strong female presence and persona was there, and it would never die and it would never go away. And funnily enough, when I then decided to transition, the male personas died completely. And that has always told me that I made the right decision, because when I tried it the other way, there was always just 2 voices, not voices, that's the wrong word, but 2 presents in my mind. Whereas when I tried it this way, there's only one. There's only me as a woman. There's no male persona. That was always something I had set up because the world had wanted to see me as male. And actually, I tell you this story because just be conscious when you will work with trans people that that's what they're going through. They're going through a battle over the person that the world wants them to be versus the person that they are, and it can be absolute torture. It took me years of splitting my attention and trying to focus on meeting both sides of who I was, which I wasn't capable of, and which wasn't right for me to try to do because that wasn't really who I was, and it was hard. Encourage the individual to speak to relevant professionals to access support. There is a lot of support out there, whether that be through the GP, through charities, through the professionals. Social workers are becoming a lot more informed about these issues. Encourage the individuals you're working with to speak to people to access support. Why should you do that? Because remember that the risk of suicide amongst trans people is some of the highest that there is. And in particular, trans teens, according to the Canadian Medical Association Journal, are 7.6 times more likely to attempt suicide. And that's something that I want you to be conscious of. But also, think about how this person is going to be supported with everyone around them when they might be trans. Think about their cultural background. Will they get support, or will that make the situation worse for them? Will that make them more likely to be at risk of suicide? What is their family like? What is their support network like? What's school like about the issue? How well will school deal with any issues of bullying? Does school have a system in place, which they should do really, of how to manage the situation when children might identify differently, and how to make sure that that information is conveyed to both children at the school and parents at the school to make sure that that child can feel safe and accepted? The school should have a trans policy, and if they don't, you might need to be the voice that says, you need to put this in place. You need to tell us how you're going to manage this. And also, as I say, think about the availability of medical treatment and the long waiting lists, because that will come up a lot faster as the children hit puberty, and the quicker you get them seen, the quicker that the professionals can at least consider, is this required? Not it'll happen, it's is this required? So let me just give you, I've talked a lot about trans as a concept. Let me just give you a very quick overview of issues like name and pronouns. Names carry a lot of significance. Remember, they set the tone for how a person interacts with others. They can be a part of a person's identity, or, as I said to you before, it can be linked to a person's fluidity. They might choose a neutral name that's important to them. And likewise, pronouns are significant for the same reasons. We know about Mr., Miss, Mrs. MX is a neutral pronoun that some people choose to use. Likewise, he, she, they is a pronoun that is used quite a lot as a neutral pronoun. Be respectful of these things. Comes into play every day, so many times a day. How many times does someone refer to you as he or she a day? If they get that wrong, a lot of the time, the compound emotional harm that is done to the individual, it's quite sad, really, and it can be very upsetting. And as I said to you earlier, remember that when it comes to pronouns, when it comes to name change, there's nothing that's said that says that a person can't be called the name that they wish to be called. The legal name is only a formality when coming into parts of the state or formal society. And I'm not going to cover it today, but again, if you want it, I can do a whole presentation on the issue of how to assist clients you might work with and children to update things on a legal perspective via passports, driving license, how to make sure that children who will go through GCSEs and A-levels can make sure that their legal names are recognised on qualifications, how to make sure that HMRC respects their identity when they become adults, etc., etc. How does a person change their name then? I just want to cover this very briefly, that a legal name change can happen through two routes: statutory declaration and deed poll. I'm not going to go through the intricacies of that. If you want me to, I can at a different seminar. But both are valid. So when you come into contact with someone, a client, a trans child, who's asking you, how do I change my name? That's how you do it. Who's saying to you, how do I make sure a court order has my right name? And you say, well, have you legally changed your name? And they say, what do you mean by that? You say, have you done a statutory declaration or a deed poll? Do you need help to do either of these? Because solicitors in particular, and to be fair, social workers can help with these kind of things. They're not that complex. The only difference I would flag between the two is my personal preference is statutory declaration, because it's a form you fill out and you sign and say, I declare that this will be my new name, and you get it witnessed. A deed poll normally has to be enrolled, and it's enrolled in the London Gazette, which is a public record. Now, you can instantly see if Dylan becomes Francine, and there was a public record that Francine used to be known as Dylan, you can end up outing Francine. And anyone who Francine will come into contact with in employment, in social circles, in promotion opportunities that might come up, can very quickly and easily find out who Francine was previously, or what Francine's slave name was or dead name was, by going to the London Gazette. Now, in the case of WFC and D, Master MacLeod, Victoria MacLeod, who is the only trans judge in the country, had looked at this very issue, the issue of deed polls being a way that, whilst it's a public registration of a person's name change, can identify the person, can out the person as trans. And she decided that for young persons under the age of 18, so children and who are unmarried, where the reason for the name change was gender reassignment, publication should be limited to surname only, and the file should be marked private. and could only be inspected on application to the court. And application, what she means by that is application to her, because she's a High Court judge. She's not a High Court judge, she's a master sitting in the High Court. So it would have to go to them to consider that. That is a wonderful way to protect trans children, and when they would have a name change. But of course, when they hit 18, this doesn't really assist them anymore. And so I still think statutory declaration is a great way to deal with the situation, although Victoria McLeod has given as much protection as she could to them as a judge in the High Court and master. So yes, we've covered all of this. I won't touch you on that slide. On a side note, just something I wanted to flag to professionals is on your signatures to email, remember that trans people find it really hard to discuss their identity, and you might misgender them without meaning to, but they'll be scared or don't feel that they could speak up to you to correct that. What I would want to flag to you is there is a way that may help to remedy this. It is becoming more and more common practice to put at the end of signatures something like this. This is what mine says. My pronouns are she/her. If replying or emailing and you wish to specify your preferred gender pronouns to assist me, please feel free to do so. You see, what it does is it opens that conversation about pronouns. It shows your clients, the children you might represent, the professionals you will come into contact, that you are open-minded enough to show respect for their identity if they were to flag to you that actually their pronouns differ than what you might initially think. And it ensures that people feel safe and able to confide in you. It is a small give. It is actually quite tokenistic as a give in many ways, but it means that that trans person might be more inclined to open up to you and might be open to having proper discussions with you. So I would encourage you all to do it if you feel able to. Now, when it comes to trans people, one of the things I want you to be conscious of, especially in the family court, and bearing in mind we're in the middle of a transparency pilot in Leeds, is the risks to trans individuals. Remember that trans as a concept and trans individuals are still at risk of very high rates of crime, are still at risks of ostracization from communities. And I want you to be alive to the risks of the individuals, because privacy can be key. Supporting them can be pivotal to avoiding things like the high risks of suicide, and sensitivity, not misgendering, not dead naming, can be so important as well. For the Transparency Project, I have raised it before, and I raise it again, that there might be cases with trans individuals where the media should not be reporting because there is a risk of them being outed to family, to friends, as a result of being trans. Trans people are not that, it's not that common. So if the media was to publish a case that says, 5 children known to a trans parent who is the children's biological father, blah, 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 in X area, jigsaw identification might identify that person. But more than that, please also be mindful that even if that person isn't necessarily pinned down and outed, that those in intersectionality groups, and by that I mean those who have cross issues that can impact on them, so they're not just trans, they could be Asian and trans, they could be Black and trans, are at greater risk of being targeted as a result of the racial and cultural issues that come around being trans. That there is a greater level of transphobia in certain communities that mean that if the media was to identify that person as Asia or as Black and also trans, those members of that community may target that individual. And so for me personally, if I have a Transparency Project case and a pilot comes up and my client is trans, I oppose this because of these unknown risks. And it is always worth flagging that to the judge, and that might not be the case to be allowing the media to sit in on and report on. So remember that, as I say to you, violence against transgender and gender non-conforming people is a tragic result of society that devalues our lives, with Black and brown trans people facing significantly higher rates of harassment, bias and violence. On the 16th of November 2022, it was reported that 32 transgender people had been killed in the USA last year, which is quite a high number to say how small a community the trans community is. And you might be thinking, well, that's over the border, that's in America, we know what the Americans are like, say that loosely. But don't be fooled, this is real even in England. In the UK, from the government's website on hate crimes recorded by the police, 1,727 to 2018 against trans people, up to almost 4,500 in 21-22, up 56% from 20 to 22. Sorry, 21 2020 to 21 to 21 to 22, 56%. Now, I have my own views on why that is. I think it has a lot to do with the media and the fact that trans issues are now, everyone seems to want to have an opinion on where I should have a wee these days. And that seems to be the greater focus than, I don't know, funding our NHS for some reason. But as a result of everything else going on in society, the risks to trans individuals has escalated significantly. And you should be alive to that in your practice. I'm just looking at the time. Remember that the most vulnerable, even within the trans community, are the intersectionality people, the people who have two things that overlap that may harm them, because intersectionality issues compound the difficulties faced by trans people. So those from racial minority groups who happen to be trans, those who have social mobility issues, come from very poor backgrounds and are trans, or those who have learning difficulties and be trans, they may not even be able to stand up for themselves. And actually, they may be the most vulnerable and most targeted. Be conscious of that when you work with trans people. Do they have these overlapping issues that might impact on them? Do I need to step up and be their voice in a greater way? Be alive to other forms of discrimination. So, sadly, we don't live in a society where direct discrimination is a thing. No one comes up to me and goes, we hate you because you're trans anymore. But unconscious bias and other forms of indirect discrimination, jabbing at me in slight undertones, might be a way that I am attacked. So, for instance, one of the ways that you might find that clients are attacked in court, or witnesses can be attacked if they're trans, is misgendering. And whilst we all do that instantly, there may be people in court who you notice are doing this on purpose as a way of undermining that individual. Tackle that. Don't be afraid to tackle it and be alive to it. That whilst innocent mistakes happen, if it is a pattern, an ongoing pattern, it may be part of something else. I've talked to you about how transgender people can access support. The only thing I want to flag is with social services, yes, they have a lot more knowledge, but also remember that local authorities have certain duties to children in their locality. And their duties may involve having to support a trans child in a particular way, Care Act assessments, ensuring that on the SIN plans or child protection plans, they assist the family to get the child the proper support through the gender clinic. Don't be afraid to flag those issues to the local authority. Their duties will extend to trans children as well. And so the second part of what I wanted to cover with you then, that was an introduction to trans and all the issues that trans people can face. Let's see what the family court thinks about it and what you need to be aware of then. I think it's right to say that the family court largely recognises and agrees with everything I've just said to you. Certainly the guidance in the Equal Treatment Bench book, which we'll come on to in a moment, recognises the risks to trans people, the importance to identify their identity in the right way. Well, let's talk about what the law says. So I'm going back some time now. I'm going back to 1977, but I think it's important that we understand how the world has changed and that the courts have changed. In the family court in 1977, it's right to say, and I think I would I would openly say that there was an anti-LGBT rhetoric back then. I mean, in this case, for instance, in Reedy in 77, and some 70 isn't that long ago, really. In some respects, society has changed its views to homosexuality so that it no longer interferes with what adults do between themselves. It had been decriminalized at this point, or considers that it should be a criminal offense. But it remains unnatural, and society continues to disapprove of it. It is most dangerous for a young person to come into contact with it. This was what was expressed about gay people in 1977 from the family court. It was a case with a gay father, and he had a son, and he was fighting for contact. And what we have is, if he associates with his father, he will learn about homosexuality in a most damaging way through the peculiarity of his father. It is inconceivable that he would not learn, not who his father is, by the way, what his father is. Boys of his age, very inquisitive and perceptive. 1977, guys, this is what the family court was saying. He might come across things which may scar him for life. That's what the court was saying. 1991, a case of a lesbian couple with a child. Even 91, and I remember 91, and I think a lot of you on the link will remember 91, the court was saying and made a supervision in an order in a case because this was a lesbian couple, because the child in this home must be regularly, carefully, and discreetly watched by one of those trained to do so, by whom I mean a welfare, probation, or other suitable officer. It was considered being LGBT was considered a welfare issue for children, if your parent was. Thankfully, we then had a series of changes in the law. In 2000, equality with the age of consent for sex. Section 28 repealed. Adoptions by same-sex couples come in, and we have all the ways that same-sex couples can now have children through the Human Fertilisation and Embryology Act. And everyone's hero, Lady Justice Hale, gave her case in 2006 and said the issues arising are just the same. This is for LGBT people. LGBT people and heterosexual couples, the two groups, the issues arising are just the same as those which may arise between heterosexual couples. The legal principles are the same. And for the first time, being LGBT was not automatically a safeguarding concern. For the first time ever, thanks to this wonderful woman, who I think we all have a wonderful story to tell about, the real issue was refocused, and what mattered was the welfare of the child and not the parents' identity. In the end, the only principle is the paramountcy of child welfare. That's what we're coming back to for lesbian couples again. So, before I move on, I just want to say that when you will work with trans people in the family court, remember that the issue comes back to the child's welfare and has nothing to do with whether or not that person is trans or even whether the child is trans. The welfare principles are now the same, and you have the guidance there to say that. Let's look at, more specifically, some transgender cases then. Now, Peter Jackson, as he then was sitting as a High Court judge, and he had a case where a father had transitioned and the father had left the Orthodox Jewish community, which was a very strict community when it came to things like trans issues. And this father, now a woman, had sought contact with the children who were still in the community. To be fair to Peter Jackson, I've met him at a couple of events and he talked to me about this case. I think this was a case that always stays with a judge. This is my opinion, not his, not what he said to me. And I think this is one of those cases because Peter Jackson had tried everything he could in that case to try and get contact up and running. But the risk to the children was that they would be ostracized from this community if they had contact with their father. And the community was so close-knit and tight that they received a lot of support from the community. A lot of their identity was formed as a result of being part of this community. And so Peter Jackson, in the end, said, I have reached the unwelcome conclusion that the likelihood of the children and their mother being marginalized or excluded by the ultra-Orthodox community is so real and the consequences so great that this one factor, besides its many disadvantages, must prevail over the many advantages of contact. And he felt that he couldn't direct contact for the father. It's interesting because the judgment gives like 14 different reasons in favor of contact, but felt that this one factor, the children being ostracized and marginalized out of the community, was so great for the children that, notwithstanding those 14 positives or so, Peter Jackson didn't feel able to direct contact. Well, what did the Court of Appeal say? The Court of Appeal said, no, you're wrong, that the trial judge gave up too easily. And what the Court of Appeal said is, never say never. The doors should not be closed at this early stage in the children's lives. And I flagged this case because it's very important to show that when it comes to transgender parents, the court is not going to entertain or should not entertain concepts that as a result of being trans, you should be denied access to your children, or you should not be given the opportunity to parent, or that you are automatically a risk to your children. The court was very clear that contact is important and being trans is not enough to stop it. Where does that leave us? Well, sadly, it went back to a different High Court judge who, again, tried everything they could to get contact up and running, and it couldn't work. And in this very sad case, it had to come to an end with no contact. And to be fair, the children's father, as she then was a woman, recognized this herself and backed down. In delivering this short extempore judgment, I am intending to bring closure to this difficult and challenging case in the hope that this courageous family may move forward without the added burden of public comment. I have also made specific orders restricting the father's campaign on social media. It requires to be said that she has submitted to these orders without any opposition. And it was a very difficult case because, notwithstanding the best efforts, contact couldn't be promoted because of the risks of being ostracized and excluded from their community. But it did send the message that the trans community, by virtue of being trans, should not be denied access to children, should not be denied an opportunity to be a parent in their children's lives, and are not automatically a risk to children. What do we take from this? Well, from the case law as a whole, it's about a welfare analysis that doesn't include systemic prejudices based on an LGBTQ identity. The judge has a positive duty to promote or to attempt to promote contact, and must consider all options really in attempting to do so. Contact should only be stopped as a last resort, and it really has to be the extreme of this type of case. And LGBTQ is not a reason to deny someone an opportunity to care for or have a relationship with their child. Let's talk about another case. Re J 2016, private law proceedings, parents separated. The child was age 7 when proceedings came before the High Court. The mother claimed that the child themselves was gender variant and allowed the child to present as a girl. And the local authority were concerned that the mother's behaviour amounted to risk of emotional harm because the mother in this case was, in essence, and these are my words, forcing this identity on this little boy, who actually, when he was back in his father's care, had no issue being a boy. This was all the mother's doing. And so the court held that the grounds for making a care order were met. That's a useful case for you to consider if you think that this might not be genuine, that this might be an FII equivalent situation. J is perfect for that. But I want to point out Lancashire to you. Lancashire was a really interesting case because it involved foster carers who had a series of children with them, and the local authority were concerned about the care they were delivering. And the judgment kind of focuses more on the test for withdrawing care proceedings, but one of the issues in it, and I would still encourage you to read the judgment, is that one of the children in that household, the foster carers had encouraged a 6-year-old who was to present as female full-time. And that is a very young age. It comes back to what I said to you earlier about children knowing about dysphoria from a very young age. A 6-year-old knew, or the foster carer said knew that they were female and needed to identify as female, and the foster carer supported that. The court directed a series of experts to look at this, and Dr. Pastersky was considered the expert that the court decided gave the best opinion on this. I observed during the course of the hearing that issues related to gender identity and the medical understanding of such issues is complex and developing, and inevitably there is some lag between those professionals at the cutting edge, such as Pastersky, and those in which I include myself, which might have played some role in how these proceedings came about. The court found, as Pastersky had said, that it was entirely appropriate for that 6-year-old to present as female full-time. And so I do want you to contrast J versus Lancashire County Council and TP, because TP shows you that actually even from a young age, there may be genuine, the process of transitioning a child might be genuine and for good reason and can be properly supported by evidence from experts. Other cases to note. Now, I'm not going to go through these because I'm conscious of time, but they are there if you need to know it. Suffice it to say on McConnell, it was a trans man who'd given birth to a child and didn't want to be known as the mother in the birth certificate. The court said that, excuse me, the person giving birth to the child must be recorded as the child's mother, sadly. I say sadly, that's my own opinion. And so mother will always be recorded on the birth certificate, even if the child is born from a trans man. A recent case that I do want you to know, though, is Re S, which came out this year. And this was really interesting because the parents of this little boy had decided that they would go overseas for this little boy to have gender reassignment, not full gender reassignment surgery, but a form of gender reassignment surgery, which is a double mastectomy. Sam had been assigned female at birth, lived as a boy, had been living as a boy comfortably. Parents supported this, had gone through the processes properly, and the local authority said, no, we want to invoke the inherent jurisdiction to stop this 15-year-old travelling abroad to go undergo this procedure. Just so you know, the Tavistock Clinic will not perform these types of surgeries, and in fact won't give cross-sex hormones. No cross-sex hormones until the child is at least 16. Won't perform these surgeries until the child is at least 18. But overseas, this is done, and there is nothing stopping. In fact, there is a lot of guidance to say that there are children and young adults who know and are comfortable enough to understand things from a younger age than 18 or 16, and who should be given that treatment. So whilst it's the Tavistock Clinic's policy to wait until that age, and that's the NHS's policy, private providers will provide these things sooner on the basis that there is nothing that says that it shouldn't happen sooner. That's just the policy the NHS has taken. So this child applied to go overseas, or rather was going to go overseas to have this double mastectomy. The local authority said no, implied for leave to invoke the inherent jurisdiction to stop that travelling overseas, and took the case all the way to a final hearing in front of McFarlane, filed something like a 35 or 36 page written opening saying that the court, that this child shouldn't go overseas to do this. And on the Friday before the hearing started on the Monday, McFarlane sent an email out going, can someone address me on A, a welfare analysis of why this is wrong, and B, what is the risk of significant harm to the child? On the Monday, the local authority sought leave to withdraw the case on day one of the final hearing, because quite frankly, Sam's parents had considered the options, had weighed it properly in the balance, and knew what they were doing. Sam had Gaelic competence and knew what he was doing, and his guardian therefore supported, having considered these matters, that it was in Sam's best interest to do this, and the parents were within their realm to make this decision, and that Sam wanted this. And after McFarlane flagged that to the local authority, they sought to back down. McFarlane was very scathing of them in the judgment about the way that they had tried to use the inherent jurisdiction to stop this little boy, when actually they could have had a care order for a start, and the inherent jurisdiction should only be used when there's nothing else. But more than that they had left this so late and caused Sam so much distress because these proceedings had been drawn out and Sam couldn't have his surgery, when in fact it should have been obvious to the local authority much sooner that this was the case, that it was absolutely fine for Sam to have this procedure overseas. And so costs were sought, and the local authority had costs orders made against them. So I flagged that case because if you have a local authority who takes this step, or if you are worried about these types of things, RIES is a very recent case about it to assist you. So that is, I'm conscious of time, that is a basic overview into the concept of trans, and we've also covered what the law says, and when it comes to children and making decisions, the fact that the welfare checklist or welfare analysis is still relevant, and being LGBTQ is not an automatic bar or stop anymore. Let's talk about then a little bit of the pragmatism of what you do when you're in the family courts for trans people. For those of you who don't know, there is a book called the Equal Treatment Bench Book. It is a book used by the Judiciary of England and Wales, and it's referred to in their training courses, and it's commended by the appellate courts. So the appellate courts tell them to follow this guidance in the book. The bench book not only doesn't express the law, but it gives them good guidance on how to deal with things like how to treat women, things like gender issues in the world, things like, as Chapter 12 covers, trans people and how to treat trans people in the court. And I would urge all of you as practitioners, if you come across trans individuals, to look at Chapter 12 of the trans people, the Chapter 12 in the bench book, because it gives you the full guidance of what is expected good practice when you come to court. So, what does the bench book say then? Well, I'll cover it briefly with you. It is important, these are some extracts I've pulled from it to assist you to understand the tone of this chapter and what the book says. Sorry, excuse me. It is important to respect a person's gender identity by using appropriate terms of address, names, and pronouns. Everyone is entitled to respect for their gender identity, private life, and personal dignity. So coming back to what I said to you before, make sure you get these things right. It is inappropriate to inquire about someone's medical history, including their anatomical status, unless it is legally relevant to the case at hand. If it becomes relevant, the issue should be handled with an utmost sensitivity and respect for the person's private life. Again, a private hearing might be directed. I would say to you, it's very rare, if ever, do you need to know what someone's anatomical situation is. What's between people's legs is no one else's business but their own. So you will very rarely have that as an issue. Just forgive me for a moment. I'm in court delivering this because I have a matter to stand down this morning.
Thank you.
Okay, so let's go through some further ones. So fundamental principles of equality and acceptance of diversity demand that no prejudice or difference in treatment is accorded to a person due to appearance, including the manner of dress. And again, that means that people can dress in a gender neutral way. If they wish to come to court, your trans clients can dress however they feel comfortable. Any person's gender expression and choice of clothing should be respected unless there is an affront to public decency or a clear intention to insult the judicial process. This applies equally to all people, whether transgender or not. It should be possible to respect a person's gender identity and their present name for nearly all court hearing and tribunals, regardless of whether they've obtained legal recognition of their gender by way of a gender recognition certificate. Now, this comes back to the point I made to you earlier, which is even if someone doesn't have legal recognition that they've transitioned to a gender recognition certificate or legally changed their names, we can still respect them. We can still show acknowledgement of who they tell us they identify as without having, even in the court system, even on court orders, without having to belittle them. So, what does the book tell us to think about? Well, it tells us that transphobia is real and has to be considered, that there are real risks to trans people if outed, which should not be ignored, that the unwillingness of trans people when it comes to participating in hearings, if they're not treated properly, or if they feel that they're at risk of being outed, is a real thing. And we have to be conscious of that we can make people unwilling to take part. That there is a significant effect on trans people if you get it wrong, and then trans people might not want to use the court if they don't feel that they're not respected. And you as practitioners need to be conscious of that. What's good guidance from the bench book? Well, what I would say to you is make sure, as I said to you earlier, record on the first order the person's legal name, but that they would like to be known as X, and thereafter use X on all orders and legal documents. Record on the first order the person's preferred pronouns, thereafter use the pronouns. Medical history. It will be very unlikely that a person's medical history will be relevant. Remember, the focus is on welfare for the child. And I've had cases where, for instance, people will say, well, you know, that trans woman is on medication, will be growing boobs, will be changing her appearance. That's not good for children to see. The court does not entertain that. That is part of systemic prejudices, and it's not acceptable. And you need to, as the advocate, be able to fight that and say it is about welfare of the child. These old-fashioned ways of thinking are no longer relevant. Know your terminology. Know what's acceptable and what's relevant terminology so you're not offending. Remember what I said about gender-neutral clothing, or people wearing whatever they feel comfortable in. Remember, misgendering or using other forms of disrespect can be used as a tactic against trans people. And what we discussed earlier about your opponents might want to misgender to undermine that witness, to undermine your client. Don't let that happen. Interestingly, though, the Equal Treatment Bench book is silent on what should happen with toilets when you're at court. And so there is no guidance on this. I will give you what I think good practice should be, which is that a person, however they identify, should go and use the toilet that they identify with. So as a trans woman, I would use the women's toilet. If your client is worried about that and uncomfortable, then there are those, sadly, disabled toilets, but they are gender neutral toilets technically that your client could use. I never like the idea of a gender neutral toilet being a disabled toilet because it carries connotations that are not right and are not accurate. But it is a gender neutral toilet if your client feels uncomfortable with it. That's my guidance for you on the issue of toilets, since everyone else in the media seems to want to talk about it. Standing up for trans people in the family court. Now, what I would say to you is don't sit idly by. Flag to judges the guidance from the Equal Treatment Bench book, because a lot of judges don't actually know excuse me, A, what the Equal Treatment Bench book says, but B, what the higher courts say around welfare and all of the points that I've been through with you. Do them a skeleton argument at the start of the case. Do them a position statement at the start of the case. Tell them what good practice would be. I have found that whilst judges don't know about this, once you flag it to them, they're ever so grateful, and they definitely agree with you about names on orders and pronouns on orders, and they do it. So don't assume your judge will know, because they don't normally read the bench book, but they know what it is, and if you flag it to them, chances are they'll follow it. They'll be scared not to be honest with you, because there's complaints territory if they don't. Secondly, remember to correct practitioners if they get things wrong. I appreciate innocent mistakes happen, but be conscious of what I've talked to you about it being used as a tool. I put a quote there, and I have to apologize. It's quite an arrogant quote, because it's a quote from one of my articles on this, but I couldn't think of a better way of capturing it other than to quote what I said, so I'll read it to you. Given the lived experiences of trans people, there are issues around their self-esteem, their ability to work with others in a constructive way if they feel that they are facing some form of discrimination, their ability to challenge others, and their ability to speak up and properly engage with difficult issues. A lifetime of being put down can seriously impact on a person's ability in what is a scary and a complex arena, court proceedings. Remember that. Remember that you can be their voice, especially for your clients, for witnesses, and for children, because I think for children, it upsets me the most, because I think that they are unheard of. I'll come back to that. In fact, I'll come back to children in a minute, because there is more that I want to be saying about that. Remember to look out for direct and indirect discrimination that we've discussed. Remember what the Women and Equality Select Committee report said in 2016. Whilst Britain has been among the countries that have gone furthest in recognising LGBT rights, our society is still failing this test in respect of trans people, despite welcome progress in recent years. So trans persons' fears of discrimination and harassment and risks to them, it's not fanciful. It is real. It is around us all the time in the statistics, in the reports that have been published, in the Equal Treatment Bench book. It is real. So one of the things you might want to think about as part of considering how to protect trans people
Can
is...
Ms. Persaud and Miss Latter please report to the Justice? Thank you.
Bear with me a moment, guys. Do you mind checking what the judge wants me for? I've got until 2:30. I've got an accommodation to do this seminar, so I'm not going anywhere. One of the things you might want to think about is, does this particular client or individual, a witness, a child, require protection under PD 3AA, which is the vulnerable witnesses, the vulnerable persons provision? Because if so, highlight it to the court, explain why, quoting the Equal Treatment Bench book, and ask for certain special measures to be put in place. If you think that pronouns, should a person's pronouns relevant language be discussed and agreed prior to the substantive hearing, i.e. put on the very first order so everyone follows it afterwards, be the person that speaks up and says that. Do you think that this is a client who might require more time to understand the process, to talk through the issues because they feel vulnerable, attacked, they feel defensive as a result of what they've been through? Raise these issues and ask for further time for pre-hearing discussions. Make sure that your client and what they go through is recognised by the court. Inform them, remind them of what the Equal Treatment Bench book says, because I think most judges will be happy to allow that. They just need to know, to be reminded of it. Will these measures in themselves provide courtesy and the required validation to the person's identity? What I put there is, if you've done all that, if you've agreed pronouns and names on order, considered the vulnerable persons provisions, etc., and you think, is there anything else I could do? Or ask your client, if you find that your client is struggling with the process, scared, seem nervous, what would make it easier for you right now? Do they need a little bit more? Would video hearings help them instead, for instance, where they can be in the comfort of their own home? Speak to them about these things. Now, I raise all of these, and I'm conscious that a lot of trans people will not require all of this, but be conscious that there may be ones who do, and you as the practitioner needs to be alive to it. Be conscious of the intersectionality issues that some trans people may be facing. Be conscious of issues of privacy, and as I said, the transparency pilot that's going on in Leeds at the moment. There may be cases where gender identity is not relevant, or where this is about children now, actually. I should tell you about this because I'm worried about this. There may well be cases where gender identity is not relevant, where the person does not wish for others to know of their identity. Now, I know that can apply to adults, and remember it for adults, but I'm particularly discussing it for children because there may be cases where a Gillick competent child tells their guardian or their social worker or their solicitor or their barrister that they identify as trans, but they don't want a parent to know. You have to be prepared to champion that cause. Remember that you can make an application to the High Court to withhold information from party to proceedings, and be willing to do that if that will assist your client. Remember that the wrong outcome can cause extreme psychological distress.
And Mr. Stevenson, for the 2 o'clock hearing, please report to the Justice.
That can particularly apply for children who might find that their trans identity gets outed and that they can find themselves ostracized or in danger or being treated in a certain way on a psychological level. I can guarantee you that if a child says, I don't want my parents to know, and then they're told someone in proceedings has shared a bit of information that now their parents know, they will remember that for life. And that is the truth. They will never forget that they disclosed that, asked for it to be kept secret, and they were outed to their parents. And you, as their champion, has to be the person that fights that cause. Remember, for children and vulnerable adults, there's a high risk of suicide that we discussed earlier. And remember the package of support that I told you could be accessed to protect them. We talked about the way that misgendering, dead naming could end up harming a person and be used as a tactic. What I would like you to do in family proceedings, and in particular in children proceedings, is also to remember that judges, for instance, giving extempore judgments, may use the wrong name or pronoun. I don't think judges ever mean to do that. I could be proven wrong, but I don't think they mean to. The way I've tackled this in the past is if I've had a judge do that, I will then say to that judge, I will stand up at the end and say, can we just be clear on the record that when Your Honour has said he, Your Honour meant she. When Your Honour referred to this name, Your Honour meant this person. I've also, in judgments, final judgments, said, can Your Honour permit me, when the word version of the transcript will come through, to amend that to correctly identify this person? And judges never object to it. But I do that because I'm very conscious that it's important for trans people that when these things stay on your record, and in particular for children who we know they have a voice in proceedings, but they're not there, they're not seeing what's going on, they're not able to respond to it, they're not able to correct the judge themselves on something that's really important for them. it is incredibly important for them that we stand up and do that on the record for them. Records are lifelong documents, but also remember actual lifelong documents, I mean physical documents, things like child permanence reports and care proceedings. Remember that misgendering a person or a child can have long-term consequences. Children who are adopted can get their CPR, and chances are do get their CPR, to read and know what their family and their life was like and why they got adopted. If that CPR talks of a sister or a brother who is now a sister, and they think, I want to reach out to this person, I know I have a brother, and actually they have a sister, that can be incredibly distressing for them, because that's all the information they'll get, that's all they'll ever know. And if they ever find out, I thought I had a brother, and in fact I had a sister, that would really upset them. So when social workers have drafted these documents, check them. Make sure that trans issues are dealt with, not because it's obvious in the moment, but because there are children in these proceedings who rely on us to correct the record and correct documents that they will see in later life, and they need the accurate information for. I've said there are issues, therefore, that you can tackle and address. There can be a huge difference for the adults involved and the children involved. And remember that for children who are voiceless or semi-voiceless in proceedings, this can make a big difference for them in future. So therefore, when we look at this whole, what do we have? We have a broad overview that we've covered about trans as a concept, terminology, pronouns, titles. I've given you the relevant law around LGBTQ issues and where the court sits in terms of decision making for children and the importance of welfare and not systemic prejudices. And I've given you some guidance from the Equal Treatment Bench book around what good practice could look like when you're in a courtroom championing the cause of trans clients, witnesses, or even children. So that's what we've covered today. I hope that was really helpful to you all. I can only apologise that I had to deliver this from court. My case ran on to the afternoon, but I do hope still that you've learned from it. If you have any questions, do get in touch. There is a lot of information I can deliver on trans issues around the medical side, around the social side, and other things that may come into your practice that you need to be aware of, especially if you represent trans children. And if you want to know that information, please let me know, because I can deliver a seminar on that. And if you have any questions, let me know. But otherwise, have a good day, and thank you for attending.